First, we're going to talk about the Freelance Isn't Free Act. This is New York legislation that will take effect now August 28th of this year. So the New York State Freelance Isn't Free Act is a state law that will apply generally across the state. There was originally a provision of the New York labor law that was going to take effect much earlier and would already be in effect now. That got delayed by an amended piece of legislation. So now this is addressed in the general business law at section 1415 for anyone who needs to obtain that statute. In addition to what I'm going to discuss today, for those of you with employees in New York City, you may be already familiar with the New York City Freelance Isn't Free Act, and that has been in effect since May of 2017. I think I referenced employees in New York City, specifically the New York State and New York City Freelance Isn't Free Acts are designed to address employees who are not, in fact, employees. So what types of individuals are being addressed by this legislation? Well, it defines the term freelance worker based on these various points. First of all, it's any natural person or organization composed of no more than one natural person. So a business entity, a corporation or LLC that has multiple owners or staff members, employees, etc., does not count as a freelance worker. However, if a single sole proprietor of a business that is just the one person happens to be incorporated or have an LLC, which is certainly possible and common, then they can still be, through that entity, a freelance worker. As the next point indicates, they don't have to be incorporated or have a business name to be considered a freelance worker, but if they do, that does not preclude them from being a freelance worker under the law. This freelance worker is hired or retained as an independent contractor by a hiring party to provide services. So what we're ultimately talking about here relates to the distinction between employees and independent contractors. Employees are covered by other legal parameters, and this Freelance Isn't Free Act is not trying to duplicate or replace what the labor laws already cover. It is designed to extend protections to workers beyond employees who are considered independent contractors. The hiring party presumably is your business or the employer slash hiring party of an independent contractor, and we'll go into that definition more in a moment. The freelance worker has to be providing services in exchange for an amount of at least $800. And that $800 threshold is either based on an individual service or payment, or when you aggregate all of the contracts for services between that same person and the same hiring party in the past 120 days. So if you were paying someone $100 a week, for example, then over the course of 8 weeks, you would get to $800, and this Freelance Isn't Free Act would be triggered because that 8 weeks is less than 120 days. There are some categorical exclusions. First of all, sales representatives are already covered by a provision of the New York labor law. Again, these are sales representatives defined separate and apart from employees. So obviously you might have employees identified by title as sales representatives, or that is the nature of their work. There are other provisions and requirements under the law for employees who are commissioned salespersons, for example. So some of this obviously can get a little confusing, but independent contractor, sales representatives are not covered by the Freelance Isn't Free Act if they meet that definition of the labor law, because there's already statutory requirements for contracts and payment there. Lawyers who are legally practicing law are excluded. In other words, if you hire a lawyer who happens to be a sole practitioner, then they might otherwise meet the definition of the Freelance Isn't Free Act, but the law will not apply as long as you're hiring that lawyer to practice law in a way that they're authorized to do. That being said, if you hire the lawyer to do something that doesn't have anything to do with practicing law, to file papers in essence that aren't filing legal papers but are just literally organizing your files, then the law could still apply. Licensed medical professionals are excluded. So obviously doctors and nurses are the primary categories there. And construction contractors are also excluded. Relatively uncommon to have individual construction contractors. More often, they're going to be part of a business entity that's larger than one person, but there certainly are single-person construction contractors, and they are not covered by this law if that is the case. What is a hiring person? Well, it's any hiring party, any person who retains a freelance worker to provide any service. So that is pretty broad. The clear exclusion is for government entities. So any person means you don't necessarily have to be a business. If you hire someone to perform work at your home, for example, you are still a hiring party. And if the other conditions for that person being considered a freelance worker apply, then the provisions of the Freelance Isn't Free Act are going to apply. Note that government entities are excluded, which I guess is a nice side effect of the government creating these laws, is that they can carve the government out of coverage if they choose to do so. So if you do work for a town, village, county, public authority, then you're probably not subject to the Freelance Isn't Free Act in that capacity. Again, you may be subject to it if you're personally hiring someone to perform services for you in your independent personal capacity. So why does it matter if the Freelance Isn't Free Act applies? Because if it does, you have certain contractual and payment obligations. Namely, if you are going to engage a freelance worker and you're going to meet that $800 threshold, then you must have a written contract governing that relationship. These items of information must be included in that contract: names and mailing addresses of both parties to the contract, itemization of all the services to be provided, the value of those services, the rate and method of compensation, the date or mechanism of determining when payment will be made, and the date by which a freelance worker must submit a list of services rendered to allow the hiring party to process timely payment. Now, different of these items are going to be more or less common or easier to include. In some cases, there's going to be a flat fee. Person does X and the pay is Y. In other cases, as the last item on this list demonstrates, you won't know exactly what the total payment is going to be until after the work is done. And the different requirements here are designed to somehow collectively encompass all the different circumstances. So It may be that there is never going to be a submission by the freelance worker of a list of services rendered, and that's not necessarily going to invalidate the contract. The point is, if that's relevant, then it needs to be included. Presumably, if that's not relevant, then the terms are going to otherwise make it obvious that that's not necessary. For example, but what are the consequences of not having a contract, or in essence, not having a compliant contract by including the required terms? Well, in that case, the freelancer can assert a violation of the act just on the basis of not receiving a contract. But to assert that type of claim, the freelancer would have had to have requested a contract before beginning the work. So the burden to some extent is on the freelancer to request a contract. And if they didn't, but do the work anyway, then they can't make a claim for failure to provide the contract. However, even if they didn't make the request, the hiring party would still be at risk of evidentiary presumptions in the freelancer's favor if there was, in fact, no written contract. In other words, the ultimate burden is on the hiring party to ensure that there is a compliant contract, because if they don't, then the freelancer is going to be given more discretion in offering what they believe the arrangement was intended to be. And again, if the hiring party refused to provide a contract after the freelancer asked for it, the fact that the freelancer then nonetheless went on and performed the work isn't going to be held against the freelancer. At that point, it's going to be held against the hiring party, up to the point that there's even a claim just based on the not having a contract, independent of whether the hiring party makes good on what the arrangement was actually intended to be or not. The law ultimately is trying to get at what other provisions of law do to protect workers by being paid what they need to be paid. In other words, if you have an employee, New York state law is going to require that person be paid within a certain amount of time, all amounts that they're entitled to be paid, but there's otherwise no general statutory provisions that require the independent contractors of the world to be paid or provide for damages if they're not. Now, certainly there could be breach of contract claims, for example, in those situations, but they don't have the full range of remedies available as employees would in cases of non-payment. So the law is specific that payment must be made either by the date specified in the contract, or if it's not specified, within 30 days of completing the freelance worker's services. So that's not to say that all payments have to be made within 30 days of the work being performed, but if there's not a contract, or the contract isn't clear to that point of when the payment is supposed to be made, then the 30-day presumption will apply. The law also prohibits hiring parties from demanding that freelancers accept less compensation than contracted as a condition of timely payment. Now, there is some potential uncertainty here in the case of a contractor who doesn't provide the services that were expected, and I would encourage hiring parties to ensure that their contracts address that scenario as clearly as possible. But ultimately, if there isn't a contract, or the contract isn't specific enough to demand certain performance, then once the freelancer says they've completed the job, then there's a risk if the hiring party doesn't make payment in full in a timely basis. And at that stage, the law is saying the hiring party doesn't have the liberty to go to the freelancer and say, if you want to be paid on time, you're going to accept 80% or whatever of the original offer. So what are the penalties? Basically, the law borrows from the wage payment remedies under New York labor law. So where historically, if an independent contractor is not paid, they would have a breach of contract claim, and a breach of contract claim might allow them to recover their actual loss from not being satisfied on the contract. Breach of contract claims typically don't include things like double damages or recovery of attorney's fees and costs, which are more typical of wage payment laws, including New York's wage payment laws. So now the statute will allow the contractor who's not paid what they believe they should have been paid to sue and potentially recover double damages, either for late or for non-payment, as well as their attorney's fees and costs. It also provides that there's a 6-year statute of limitations regarding the payment issue, which is consistent with the 6-year statute of limitations on breach of contract claims. There is a shorter 2-year statute of limitations on the claim of failure to provide the contract. So if the claim is just the technical violation of I requested a contract and they didn't provide me one, then there is a cause of action there, but that would have to be brought within 2 years. The main reason why the effective date of this law got pushed back is the governor didn't like the original legislation that was going to give the Commissioner of Labor the right to enforce this new statute. Instead, the compromise was that the Attorney General's office can enforce it, in addition to the freelancer having their own right of action to pursue a lawsuit if they so choose. And when the Attorney General pursues it, they can seek civil penalties, fines that would be payable to the state. Basically, Governor Hochul said that this would put too much of a burden on an already strained Department of Labor. So for those of you who have other dealings and cases and relationships going on with the Department of Labor, or you wonder about different guidance that they provided or haven't provided, then the governor is basically conceding that they are overworked and understaffed for keeping up with all of the new regulations and restrictions that the legislature has decided to put on employers. As with most of these types of laws, retaliation is also prohibited. So if someone does make a claim for payment, you couldn't use that against them, even for the purposes of, say, not wanting to contract with them in the future, in similar ways that you couldn't retaliate against employees. So it really does serve in numerous ways to treat independent contractors more like employees without specifically changing the standard between who is an employee and who is an independent contractor.